A convicted felon has, as a consequence of his crime, not only forfeited his liberty, but all of his personal rights except those which the law and its humanity accords him. He is for the time being a slave of the state. This comes from a court case called Ruffin v. Commonwealth in 1871. My name is Cherie Dawson-Edwards. I am here to preside. I know that sounds so fancy. In my conferences, we don't say that, but I appreciate being the presiding person tonight. But I'm here to preside over this panel. So I'm going to do a little introduction and then turn it over to the experts that we have here. Many years ago, like many of you, I embarked on a journey, also known as a doctoral dissertation. It was a journey that seemed like it would never end. But lucky for me, or unlucky, I chose a topic that in Kentucky at least also feels like it will never end. I wrote about felony disenfranchisement in Kentucky. We are here tonight with a star-studded panel of folks, some who taught me a lot even though I'm just meeting them for the first time tonight. I know they will provide great insights to a topic that has such a troubled history and is still very relevant to policy discussions today. So I won't attempt to talk to a whole bunch of historians about history. I will leave that to Pippa. So I will, just do a little introduction because I don't really know where everyone is on how much they know about felony disenfranchisement. But felony disenfranchisement is defined as losing the right to vote due to a felony conviction. This can be permanent, like we have in Kentucky, the one state that consistently always has the same thing, with no adjustments, really. Or it can be temporary when someone is under some type of correctional status like probation or parole. It can be de facto or de jure. De facto disenfranchisement comes from a series of complicated and complex processes and laws and lack of knowledge from people that could help people, and inaccurate and misleading information that may be out there, which leads to de facto disenfranchisement, or people not knowing that they're actually eligible to get their rights restored or eligible to vote in places that have automatic restoration. The lost votes of disenfranchised felons follow a long American tradition of selectively granting the franchise. Invisible punishments like this are less discernible and more challenging to study and change, which I'm sure lots of people are going to talk about that part tonight. They operate beyond the public view. They appear to have adverse consequences on other things like occupational opportunities, civic engagement, housing opportunities, and other types of assistance. Their effects are often estimates, but almost always have real racial implications. So just some stats about Kentucky, because anybody else in here from Kentucky? Okay, I'm from Louisville. See, I said that, so I can talk about us. Almost 1 in 10 adult Kentuckians has lost the right to vote due to a prior conviction, including an estimated 1 in 3 African American males. Now, I don't know how that makes you feel, but for me, I have to put this out there. I'm a mom and I'm a wife. And I think about when I go to Thanksgiving in a couple weeks, when I sit around my Thanksgiving table, there are going to be more than 3 African-American males there. And so that's a scary stat for me. I see that and I feel it, and I hope that you will see it and feel it as well. Maybe real numbers representing real people are more impactful. There are roughly 312,000 disenfranchised Kentuckians, including nearly 69,000 African-Americans, according to Marc Mauer in the Sentencing Project. Historian Pippa Holloway stated, "The combination of statutory revision, constitutional amendment, and judicial action forms a region-wide pattern of expanded punishment for petty theft that was identified at the time as intended to disenfranchise African Americans." So I know she's going to talk about this time period, but just to give you some context about Kentucky, our permanent ban on felon voting rights, which is how I refer to it, began in the 1850s. And our third constitution disenfranchised all people convicted of a felony for the rest of their lives and gives the right to restore it back to the executive office. Means, which Mayor Fisher mentioned, that it's up to the purview of our governor. So I just want to do a couple of quotes, and then I'll be done. On November 24th, 2015, then Governor Steve Beshear had this to say: This disenfranchisement makes no sense. It makes no sense because it dilutes the energy of democracy, which functions only if all classes and categories of people have a voice, not just a privileged, powerful few. It makes no sense because it defeats a primary goal of our correction system, which is to rehabilitate those who have committed crimes. That was November 24th, 2015. On December 23rd, 2015, our then new governor had this to say. While I've been a vocal supporter of restoration rights, Governor Matt Bevin said in announcing his order to cancel the previous order, it is an issue that must be addressed to the legislature and by the will of the people. So I'm hoping that Amanda or Mr. Reilly will talk about how difficult that legislative process is for these wonderful kind of people. So then let me just give you a quote, a more recent quote from our governor-elect, Andy Beshear. So I don't think you all understand how excited I am. So when Andy's dad did that executive order in 2015, I literally printed it out and taped it in my office. I was so excited. And then, Bevin turns around and does what he did. So this is what Governor-elect Andy Beshear said on the campaign trail. Too many Kentuckians feel left out and left behind. But Matt Bevin's unnecessary voting restrictions make it harder for Kentuckians to be involved in our democratic process. Unlike this governor, I want to lift up all of our families and believe we have a moral responsibility to protect and expand the right to vote. So I'm happy to say that this is where we are today in Kentucky. Now, I don't trust everything all the time, like the whole other Beshear thing, but this is where we are today, so I'm super excited to be here to talk about this topic in light of that recent news. So here's what we're going to do. I'm going to let the panelists introduce themselves because I will not do them justice. Each one of them will spend about 10 minutes talking about their expertise. I will just introduce them by name before I sit down. First up, we're going to have Pippa Holloway, who was right here to my left. Next to her is Marc Mauer. Then we have Alec, Ewald, Stephen Reily, and Amanda Hall. And the order that they're sitting in is the order that they will speak. And your 10 minutes, I'll give you a little warning, but then you all can just flow into it. I won't say anything in between. Sound good?
Yeah.
All right. Thank you. We'll save questions for the end, so we're going to let them speak for 10 minutes apiece. Write your questions down, and then we'll facilitate a Q&A at the end. Sorry.
Thanks for the great introduction, and thanks all of you for being here today. I'm a professor of history at Middle Tennessee State University, and probably the main reason I'm here is that I'm author of a book on the history of felon disfranchisement. I'm going to talk a little bit about that book today and its relevance to current discussions. I began my research on the history of felon disfranchisement with the present very much in mind. My understanding of the current extent and impacts of felon disfranchisement was derived in part from the fantastic advocacy and political work and policy work of many of the people and organizations represented at this table, as well as my own personal experience doing voter registration and political campaign work in Tennessee, where I live, a state that also has a huge number of disfranchised former felons. I hoped that understanding the history of these laws might contribute to efforts to change them. Previous scholarship had suggested that the disproportionate racial impact of these laws in the present was rooted in the past, but my research proved that these laws were deployed and modified in the years after the Civil War to do partisan and racial work. This part of my research seems to have had the most significant contemporary relevance from the standpoint of litigation and activism. But researching that issue also led me to dig into the more complicated connections between felon disfranchisement and other institutions, most notably slavery, but also broader elements of legal and political culture. Today I'll talk briefly about these two sets of conclusions, the more narrow and practical, and then the more theoretical and far-reaching. First, felon disfranchisement's work in the role in the establishment and protection of the Solid South. I found significant evidence that disfranchisement for often fabricated allegations of criminal behavior were used to target African American voters beginning in the first election after the Civil War in which they were able to vote. One of the most emblematic and jarring examples of this practice came on the eve of the elections in 1867. In North Carolina, a group of white Democrats undertook a campaign of mass whippings of African American men to disfranchise them. A U.S. Army officer explained the situation this way. White former rebels, he said, conspired to, quote, seize Negroes and procure convictions for petty offenses punishable at the whipping post, and thus disqualify them forever from voting. He explained that this was due to the fact that in North Carolina, individuals whipped as punishment for petty crime lost the right to vote. Many whites celebrated how the whipping campaign enabled them to, quote, head off Congress from making Negroes voters. One legislator stated, quote, we are licking them in our part of the state, and if we keep on, we can lick them all by next year, and none of them can vote. Then, in the 1870s, these laws were used again with racial and partisan intent. They were one of several tools used to disfranchise African American voters, alongside poll taxes, voter intimidation and violence, and more. Every state under Reconstruction, except Texas, changed laws to deny the vote to individuals convicted of minor theft, i.e. misdemeanor larceny, through a complex mix of legal changes that varied from state to state. If an upcoming election seemed close, African Americans could be convicted of these crimes and disfranchised. Laws against misdemeanor theft could be enforced selectively thanks to biases in the criminal justice system. I was not surprised to find that these laws were deployed to do racial and partisan work in the decades after 1865, though I was glad I could contribute this knowledge to those working to change these laws today. But I didn't expect to find deeper racial origins of these laws in the early 19th century. Tracing the longer history of these laws has led me to analyze first the connections between violence and loss of citizenship rights, second, legal culture and the idea of infamy, and third, the connection between slavery and incarceration. And I want to talk about these three issues briefly. First, violence and loss of citizenship rights. The North Carolina example was my first clue to a kind of startling conclusion that being a victim of violence could be used as evidence that you should not have the right to suffrage. My second clue was statements made at the North Carolina Constitutional Convention of 1835 when delegates debated voting rights for free black men. There, a white delegate named Jesse Wilson made a curious argument against allowing free black men to vote in that state. Wilson asserted that such men should be disfranchised because they were victims of vigilante violence. Quote, a white man may go into the house of a free black, maltreat and abuse him, and commit any outrage upon his family, for all which the law cannot reach him. This violent assault would not be prosecuted because African Americans in North Carolina, slave or free, could not testify against whites in court. This barrier to testimony and the vulnerability to violence that it produced proved to Wilson that such men should be denied the vote. He concluded, after this, shall we invest in him the more important rights of a freeman, the high privilege of exercising the function of a voter? This quote and other evidence indicates that in the 19th century, violence not only terrorized African Americans, but also operated on an additional conceptual level by denying them voting rights to which citizens were entitled. When I was working on the book, I kept running across the words infamous and degraded to refer to prisoners and crime. They seemed to be important but slippery terms. I had assumed that when you did something bad, you were infamous, and when degraded meant you were insulted or humiliated in some way. Reading more about these concepts, though, I found that under old, mostly forgotten common law traditions, infamy could be a function of the punishment, not the crime. Whipping or other public punishments were degrading, which meant they could make a person infamous, lowering their social status and depriving them of the respect due to citizens. Public and or violent punishments made you degraded socially and as a result deprived you of citizenship rights. You couldn't vote or testify in court if you were a convict who was degraded by infamous punishment. As most of you likely know, degraded was also a common word used to describe African Americans in the slave era. The infamy and degradation of enslaved people also stemmed from their subjugation, an infamy that extended, in the eyes of Jesse Wilson in 1835 North Carolina, to free blacks as well, who were degraded and subjugated by violence. This helps better explain the 1867 whipping story as well. Violence was degrading, degrading made you infamous, infamy meant you couldn't vote. For me, this helps connect two key features of American life today: state-sanctioned violence against certain parts of the population, and efforts to make voting harder. We can draw lines that connect these statements about denying suffrage to free blacks in 1835, to whipping African American voters in 1867, to assaults by police on young black men today, to growing efforts to disable suffrage through felon disenfranchisement laws that disproportionately affect African American communities. Furthermore, we can connect labeling ethnic and racial groups criminal with state violence against immigrant populations, with false accounts of illegal voting by non-citizens, and increasingly complex voter ID laws. I want to conclude by noting two other areas where I hope my research will have some contemporary relevance. My work tells stories of illiterate tenant farmers who scrape together money to pay court costs to apply for restoration of citizenship. Of veterans, parents, church members, black and white, men, and after 1920 women who petitioned governors and legislatures for pardons. People with prior convictions are not often seen as political actors or politically engaged. That's changing to some extent today, especially with movements like those in Florida and Louisiana, where ex-offenders are leading fights to change these laws. But finding stories of wrongly disfranchised individuals in the past who challenged their disfranchisement in court or who testified about the abuses of these laws before Congress can help build opposition to these laws. Finally, in this historical record, we can find evidence of the impact of these laws on people's lives. And I want to leave you with a few quotes. Actually, just as she left you with 3 quotes, I'll leave you with 3 quotes from this historical record from ex-felons challenging their disfranchisement in the early 20th century. In 1905, C.G. Pate petitioned the governor of Georgia for the removal of his political disabilities. Pate was an illiterate man, unable to even sign his name, whose race is unclear from the historical documents. He'd been convicted of larceny earlier that year and ordered to pay a $50 fine or spend 6 months on the chain gang. Now free, friends had raised money to pay part of his fine so he could be released early. He asked Governor Terrell to restore his political disabilities. Why was Pate so anxious to have his rights restored? He wrote that the conviction, quote, "The conviction casts a reflection not only upon your petitioner, but on his children and grandchildren." Lewis Hill, a white man, quietly expressed the personal pain that he felt at the possibility of a lifetime without voting rights when he petitioned the Virginia governor in 1910. Quote, "I am a young man, and I believe that after I am reinstated, I can go forth in this world with a more cheerful heart." And finally, Annie Tassin, an African-American woman living in Missouri who identified herself as a laundress when she petitioned the governor for her voting rights in 1932. Quote, "I would love to have my citizenship back, for it means so much to me in my life to live. As I was unfortunate and falsely accused, and it has put a black shadow on my life. And God knows I want to live a true life." Thanks.
Well, good evening. I'm Marc Mauer. I'm the Executive Director of the Sentencing Project in Washington, D.C. The Sentencing Project is a national nonprofit organization. We're engaged in research and advocacy around criminal justice reform and mass incarceration. Over the last 20 years, we've done a series of reports providing estimates of the number of people who are disenfranchised as a result of felony disenfranchisement. We've done most of this in collaboration with colleagues at the University of Minnesota. We've also been very engaged in advocacy for reform of state policies in this regard. So I want to try to paint a picture of what some of that looks like and think about how we can frame these issues and what does this mean for public policy. We start off with thinking about felony disenfranchisement comes obviously from conviction of a felony. And so it ties in with the last 4 decades of the growth of mass incarceration, where we have record numbers of people in prison today, record numbers of people who have a felony conviction. So as those numbers increase in prison and the court system, translates into felony disenfranchisement. As of 2016, the last survey we completed, there are an estimated 6 million Americans who cannot vote as a result of a felony conviction. 6 million. If you break it down by race, it's 1 of every 13 African American adults is ineligible to vote. So we've never seen anything like this in terms of the impact, and it's a very broad impact, very varied by state and what their policies happen to be. It's a very grim picture. The good news, though, is that Also, over the past 20 years, has been dramatic momentum for reform. We've seen in state after state campaigns led by a range of different organizations, including very vigorous campaigns in Kentucky, not successful yet, but very vigorous nonetheless. By our count, 23 states have enacted some type of reform to these policies. Some of these have been very substantial, eliminating whole categories of disenfranchisement. In other states, it's more modest, but has to do with providing information to people, either as they leave prison or parole, about how and when they can get their rights restored. Interestingly enough, starting just over 20 years ago, 1997, in this new wave of reform, was Texas. At the time, Texas had a policy whereby after you completed your felony sentence, there was a 2-year waiting period before you could get your rights restored. Now, maybe most of you are good about marking your date book, something you have to do 2 years from now, but that's a hard thing to remember, and it's completely meaningless in terms of what an individual should do. So the legislature passed a law that did away with the waiting period. The day you got out of prison or parole, however it would be, you'd get your rights restored. It was signed into law by then Governor George W. Bush, and 300,000 people became eligible to vote upon the legislation being signed. The most significant shift we've seen took place last year in Florida on Election Day. Many of you are probably familiar with that. Florida had been, like Kentucky, was a lifetime ban on voting with a felony conviction. So you could have been an 18-year-old convicted of felony drug possession. The judge might have sentenced you to go to a treatment program, which you completed successfully. And yet, until the day you die, unless you got a pardon from the governor, you would be disenfranchised. So after many years of campaigning, a ballot initiative gained enough signatures, got more than 60% vote last year to make it an automatic restoration of rights when your sentence was completed. We estimate that potentially 1.4 million people in Florida can now regain the right to vote. Unfortunately, opposition developed very quickly. The Republican-dominated legislature quickly passed a law that said completing your sentence means that you have to also have paid all the fines and fees associated with your felony conviction. Well, fines and fees is finally getting some attention, but it's been a dramatic problem in the justice system. Indigent defendants are often saddled with thousands of dollars of fines and fees, along with whatever time they do in prison or on probation, and dramatic numbers of them are never able to pay off these fines and fees. Some estimates as much as 80% of people can't meet these. So this is currently subject to litigation in Florida, at the Florida Supreme Court, to see where that's going to go. Much of the reform activity has centered on states like Florida and Kentucky, where it's a ban after you complete your sentence. And obviously, there's much more public support there. Many people think you've done your time. It's time to restore your right to vote and all that. But more recently, we're seeing some activity for people currently serving their sentences who are living in the community under probation or parole supervision. And this is equally reasonable. You know, we have a system whereby you're in prison, parole board agrees to let you out, go back home, live in the community under supervision because you're not a major public safety risk. You're told while you're on parole you have to abide by all the conditions of parole. We want you to get a job, have a good place to live, maintain good connections, and oh, by the way, we're still going to treat you as a second-class citizen when it comes to the right to vote. That's not a very good recipe for success for people to make it when they're coming home from prison. So there has been activity. A half dozen states have now changed their prohibition on voting when you're on probation or parole supervision, and there are still some 1.5 million people under this type of supervision nationally who can't vote depending on the state in which they live. So we've seen this reform shift. There's been some backlash, but it's been a very positive movement. It still leaves us, I think, with a fundamental question about the role of felony disenfranchisement kicking in as part of your felony conviction. And is there a legitimate rationale for taking away the right to vote? And I would argue that there's no legitimate rationale. When you're convicted of a felony, there are various punishments that the courts may impose on you. It may include prison, it may include community supervision and the like. There is some deprivation of liberty, but you don't normally forfeit your fundamental rights of citizenship. So even if you're sitting in a maximum security prison, you still have the right to get married or divorced. You can buy or sell property. You have most of your First Amendment rights. You can write an op-ed article and submit it to the New York Times, and you might get it published. We don't normally say you're not a citizen, and yet when it comes to this policy, we say, no, we are going to take away that fundamental right of citizenship from you. So why are we doing this? Well, some people would say when you're in prison, that's a serious crime, and so we need to do something. We need to take it more seriously. Even there are a lot of fuzzy lines there. We can imagine two people in two adjacent courtrooms. Each of them has just been convicted of a second burglary conviction, a second felony for burglary. The first courtroom, the judge says, I gave you a chance before in the first one, now I'm going to send you to prison. The second judge says, I've looked at your background, your circumstances and all that. I'm going to keep you in the community, have you go to drug treatment, do some other things. Do that. So same crime, two people, one goes to prison, one doesn't go to prison. So why do we take the vote away from one, not the other one? People would say, too, the severity of crime has something to do with this also. The judge decides what your punishment should be based on severity of crime. This shouldn't affect your rights of citizenship. If we look internationally, as is true of our mass incarceration policies, the United States is at a major extreme compared to other industrialized nations in taking away the right to vote. We've seen constitutional court decisions, nations as varied as South Africa, Israel, Canada, the European Court of Human Rights, all upholding the right of people in prison to vote. The Israeli court decision came in a particularly notorious case, and the court said, we have to separate our contempt for the actions of this person from his rights as a citizen of the state. If we look at other industrialized nations, Western Europe, about half the countries there have no prohibitions on voting, so people in prison are eligible to vote. Of those where there is a prohibition, it only extends to the time you're in prison, never beyond that, and certainly not after you've completed your sentence. Here in the United States, we actually have two states, Maine and Vermont, along with Puerto Rico, that permit people in prison to vote. Some of our opponents on these issues sometimes raise, the issue of a criminals voting block, if you let these people vote, as they would say. And as far as we know, criminals haven't taken over Maine and Vermont. Some in prison vote, some don't vote, just like on the outside. So I think we just want to think broadly about this. It's a battle in every state to try to change the laws based on politics of the moment, but I think as a broader vision, what does this mean for democracy? And I think if we fundamentally think of democracy, we have to be very clear about how that's distinct from whatever other legitimate functions the court system has. Thanks very much.
Thanks, Mark. I have to spend a little bit of my time trying to express my gratitude to the association for having a political science. Political science is where you go if you care about history, but you're too lazy to do the work. I'm a political science professor at the University of Vermont, and I have to thank Marc Mauer, who has really created this extraordinary 25-year-long movement, and who was a big help to me when I was a young graduate student working on this issue, and has been a real supporter of mine ever since. And also Professor Pippa Holloway, who, when I opened this PDF of her brilliant article, A Chicken Stealer Shall Lose the Vote, which I recommend to you all, and it's fascinating, well-written article, evokes, the music of Louis Jordan and Huck Finn. And I'm cited in this article, and I'm so excited because I'm validated by this, and then unfortunately she's very rudely pointing out how wrong I was. That was the purpose of the citation, but she also just has done remarkable work on this. And then, although I've only just met them, Stephen Reily and Amanda Hall, people who are actually doing the work on this issue and who make this meaningful for me as an academic. I want to talk about a central feature of the current landscape as I see it in terms of disenfranchisement and where we stand in the U.S. It's very much compatible, actually, with things that actually everybody has mentioned. But I wanted to just say really quickly a little bit of the legal background. I'm also, I'm not a historian, I'm also not a lawyer, so I'll pretend on this front too, but I have written about this a little bit. The constitutional dimension of this is a really odd piece. There's probably more people in this room who know about this than in any other room I've ever been in, actually. But the second section of the 14th Amendment has this real clunker of a long sentence. And in that long clunker of a sentence, which does a lot of different things, there's this phrase, participation in rebellion or other crime. And in 1976, the Supreme Court of the United States said that phrase in that sentence of Section 2 of the 14th Amendment means that people who have been convicted of crime do not have a fundamental right to vote whatsoever. And so states can disqualify you from voting in any messy way they want if you've been convicted of a crime. And in Hunter v. Underwood, 8 years later, the court said the only exception to that is this, or if there is explicit, vicious, and successful discriminatory racial intent behind the rules. But it set the bar for proving that intent so high that it's essentially taken race out of it. So constitutional challenges have largely failed. There have been a few others that have tried equal protection and have had a little bit of sort of success. Statutory challenges under the Voting Rights Act have also generally not been successful, but in New York and then in Washington State, in a case with a great name of Farrakhan versus Locke, which for the racial sort of implication of this policy, and then with John Locke and this was a contract was nice, and then Gregoire won the office, so that changed it. But that was a really strong Voting Rights Act challenge showing that if you can show racial discrimination in the criminal justice system, which you can say this person was disenfranchised on account of race, because race explained why they were punished the way they were punished, and because they were punished, they lost the right to vote. But the courts have not accepted those arguments. And there have been a variety of other challenges on equal protection grounds and on state law grounds. There have been some poll tax angles that have been really intriguing and sort of persuasive, at least on their face, including right now in Florida with regard to payment of fines and fees. But by and large, and I want to, Mark will correct me or sort of qualify this, but legislation has been more successful than litigation as far as bringing about reform and direct action and advocacy by people working in the field. I want to try to, again, just really quickly here, I want to try to describe a central feature of the current landscape that I think is really important, which is this, and I'll try to say it sort of really briefly and then explain. Disenfranchisement is a problem of exclusion, but right now it is also very much a problem of information, that individuals who are affected by American punishment need information and are getting misinformation from public officials, that public officials in Secretary of State's office and in counties and in towns and in cities don't know the rules. People in correctional systems don't know the rules. And I think this information problem is something that we really need to understand. I wrote an article with the short title, Civil Death, and I and a lot of others have emphasized these phrases, civil death, internal exile, caste, to suggest that when you're convicted of crime, your citizenship status is so formally degraded that you really shift into this kind of permanent, sort of durable second sort of status. And now I think it's important to understand that, like other American collateral consequences, the rules are so varied, the systems are often very porous and discretionary and complex, that it may be stupid and discriminatory, but it's a different, and I'm using stupid in the technical sense of a counterproductive policy, but they're stupid and discriminatory in a different way because of their variation, because of their complexity, and because of the porousness of these borders. So when you look across the river, I don't know which way, I'm completely turned around from the 9 miles that we walked to get here, but so in Indiana, you're only disenfranchised during incarceration. So here in Kentucky, it's indefinite. But in Indiana, if you're on probation or parole, you're eligible to vote. If we go a little bit to the east and go north into Ohio, you're only disenfranchised during incarceration. A little bit to the west, go up into Illinois, you're only disenfranchised during incarceration. So state laws are really, really varied. And nationally, there are about 20 million people with felony convictions. So most Americans with felony convictions are eligible to vote, but a great many of them don't know it. A great many people working in government don't know it. And the documents that are necessary to get them to prove eligibility are often not clearly identified or not easy to get. So let me try to walk quickly through a couple of pieces of this sort of system. Documentary disenfranchisement, right? We had this phrase de facto disenfranchisement. It's the same idea. You need to prove your eligibility with certain documents. The expiration of a waiting period or vouching letters, which I think were required in this state a few years ago to get right when Kentucky, and perhaps Amanda will tell us more about this, but in the early 2000s, you get an executive pardon for the restoration of voting rights here in Kentucky, and we have a couple of experts here who will correct me on this. Then the governor, and this was before Bevin, but required an essay, 3 character references, and the permission of the prosecutor. You could still get your rights restored by the governor, but you had to have character references and an essay and the prosecutor's permission. And surprisingly, I'm joking, the numbers of people getting their restorations plummeted. In Alabama, crimes of moral turpitude are disqualifying until 2017. I have to read this. Until 2017, there was no clear understanding of what moral turpitude was for legal purposes in Alabama. This is a 2017 statute in Alabama. This is right in the statute. There is no comprehensive list of felonies that involve moral turpitude which disqualify a person from exercising her right to vote. Neither individuals with felony convictions nor elections officials have an authoritative source for determining if a felony conviction involves moral turpitude and is therefore a disqualifying felony. So now there is a list of crimes of moral turpitude in Alabama. And if your conviction was on that list and you finished your sentence, you can seek rights restoration in Alabama. But notably, and I'm not making this up, there are some people in Alabama who are disqualified permanently. If you're convicted of certain extremely serious crimes, you're not eligible for this CERV, a Certificate of Eligibility Registered to Vote. There are some people who are never eligible to get restored. There are some who can be restored by pardon. There are some who can be restored by a Certificate of Eligibility Registered to Vote. And there are some who are never disqualified. And if you pause and think about what are some of the most common convictions that people have across the United States, certainly in rural America, DUI is not a disqualifying offense in Alabama. Simple possession is not a crime of moral turpitude. Felony possession, even felony distribution is not, trafficking is, but felony distribution is not a crime of moral turpitude today in Alabama. So by the letter of the law, someone who's incarcerated for that felony offense in Alabama should have the right to vote. It's a much, much more sort of complex and, again, sort of obscure and kind of porous kind of boundary. Some states are moving, this is a really important feature, and Mark and others have made this happen. Some states are really moving to require corrections officials to notify people of their eligibility. So the District of Columbia and Rhode Island have made corrections. An NVRA agency, which remember the motor voter law of 1993 that required certain public agencies to inform people of their eligibility, corrections has to tell people that they are eligible to vote in those states. That's at the kind of other end of this sort of spectrum. That's true in Vermont as well, where corrections has an obligation to inform people of their right to vote. And I have to tell you this, when I just learned this spring. Vermont has a very small correctional, well, everything about Vermont is tiny, it's the whole population, but Vermont sends a few hundred people to out-of-state prisons. They're currently in Mississippi, but a few years ago they were in Kentucky. And I know I'm out of time, but I have to say this is a really quick thing that I just wanted to mention. When you're in Vermont, when you're incarcerated, you vote by absentee ballot in your former town of residence. And if you want to register to vote, you write to your town clerk and ask for a ballot, and they send it to you, and then you send the ballot back in. Out-of-state prisoners retain that right. So a few years ago, there were a couple hundred Vermonters who were in prison here in Kentucky, And somewhere in a drawer in that privately owned Kentucky prison, there was a list of town clerks' offices in Vermont. So that if the Vermonters wanted to so there is the extraordinary federalism of American voting rights at work. There's one last piece of this landscape, though, that I have to emphasize, which is prosecution of people for voting unlawfully because of felony conviction, most prominently in Texas, but also in North Carolina. So if you're a person who's considering whether to vote or not, and the mayor had mentioned that voting should be as easy as possible, and you're trying to consider, if you talk about the cost of voting, let's steal from economics while we're at it, and I'm being a fraud on every discipline that I can think of at once. Economics tells us that people should vote if the cost of doing so, right, is lower than the benefits that people could get from doing so. If I've got a felony conviction, there are significant costs of determining whether I'm eligible, getting documents to prove I'm eligible, perhaps persuading a public official who doesn't know the rules that I'm eligible. But then there's also this enormous possible downside cost. If I vote in a way that's actually unlawful because the law has changed in some way or there's something else that's murky about this system, and I could face very serious consequences from it, that makes it extraordinarily dangerous for me to vote. I have a couple other things I want to comment on, but I'll save my time because I really want to hear from my colleagues here. Thank you all so much. Thank you.
Well, Alec, I have to say that as much as I love Kentucky, my adopted home state, the idea of being arrested in Vermont and having to serve your sentence in a Kentucky prison feels like cruel and unusual punishment for a Vermonter. Thank you, Professor Dawson-Edwards, for presiding. I'm very honored to have been invited on this panel, and I've spent some time trying to figure out what my qualifications for being here are, because I'm not an historian. In fact, I'm married to a member of the Southern Historical Association, Emily Bingham, who's going to be, for good reason, on a panel tomorrow. I'm a lawyer. I am an entrepreneur. For the last few years, I have been serving as the director of our Speed Art Museum, which I hope you visit while you're here. But I think the reason I'm here is because I'm going to get to remind you of something that historians already know, which is that by putting a human face on an issue, even an issue with deep structural and historical implications, you can change lives. Because my life has been changed by the faces that have been put on this issue in my life. So I want to start this story almost 4 years ago, when I found myself running for our city council, our metro council, and I was walking the streets of my neighborhood, knocking on doors, and a couple of times I found myself, I'll talk about the first time, I found myself talking to a young man in his front yard, fully informed about our election. It was a crowded Democratic primary, I'll say that. He knew all the candidates in the race. And you get to this point when you do this where you have to actually ask for the person's vote. And I said, can I count on your vote? The conversation, I thought it had gone pretty well. He said, I can't vote. And it was a shocking moment for me. I live in my own bubble, and I was completely confused by his saying, I can't vote. I'm just thinking about sort of fantastic things like, oh, he still lives, he's a resident of another state. There's something else going on. I just said dumbly, why? He said, I have a criminal record. And I was really, really confused. I mean, not confused in a logical sense. I didn't know what to say, and all I could say was, I'm sorry. Because I wanted his vote, but also I was really sorry that this had been done to him. And so this data point that I knew the generalized facts of disenfranchisement, the loss of civil rights to people with criminal records, it suddenly had a face. And I had to sit with that fact. So fast forward a little bit. I didn't win the election. I came very close, but my life went on. And I joined the board of our Urban League. I have actually become a big fan of the leader of our Louisville Urban League, a charismatic woman named Sadiqa Reynolds. And she had actually been there for me. So again, thinking about human faces, I had been working on a big urban redevelopment project that didn't end up happening. But when I was doing that and she took her leadership position, she said, what can I do for you? What can we do to make this thing happen? And that meant a lot to me. So when it was my opportunity to be able to join her board, I said, what can I do for you? So in my position on that board, I was paying attention to the issues that she was working on and how they were serving their clients at the Urban League. The Kentucky legislature, meanwhile, did do something for Kentucky. It was quite progressive. We passed our first law allowing the expungement of criminal records. The problem was it was really expensive. $500 per felony and over $100 per misdemeanor. And as you may or may not know, most people who have criminal records have multiple records. Most people who are convicted of a crime are convicted of multiple crimes at the same time. So the fact was that the legislature, whether they knew it or not, were really requiring people to come up with thousands of dollars to be able to take advantage of this new opportunity. The result was that people, Alec has made this point, it's really important to recognize the result was people didn't know about the right. Because if you think about the ways you access information, it actually depends on your ability to access the right. And so all these people didn't know about it. In fact, the Urban League got a grant from Metro Council of about $15,000 to help fund some of the expungement fees. They couldn't tell anyone about it because they knew that it would be immediately overwhelmed with demand. So they were helping some of their clients who were working on workforce opportunities or other housing opportunities. They could kind of slip them in. And when I heard this, I said, this is ridiculous. There are all these people who need to be able to take advantage of this new right, but they can't. Because we are saying in Kentucky that your level of citizenship depends on your level of income. And so I was in the opportunity to say, what if we made this a really big opportunity? What if we took cost out of the equation? And so I said, as a philanthropist, I will fund the opportunity to make this as big as it can be for the next 3 years. I talked to some friends and they said, well, why are you taking advantage of what's really a wrong way to solve the problem? We need to make it automatic. We need to do the problem. I said, we have to be able to put a face on the problem because these people don't even know they have the right. Legislators and this broad bipartisan coalition, Senator Rand Paul, our chambers of commerce, our liberal congressmen and others, our mayor, want this to happen, but they don't even know how to tell the story. So let's get that out of the way. So the Urban League declared a new clinic. They got people ready. We got wonderful, generous lawyers to volunteer. And on a cold, snowy Saturday morning in February at 7 a.m., about 800 people showed up at Roosevelt Perry Elementary School in West Louisville. So that's a sign of a number of things. One is the degree to which that information had not been available to those families, or if it was, they had no idea how to access this new right. Because of the cost. You had to get a lawyer. You had to have the fees in the bank. And these are people who can't get a job with benefits because of their criminal records. So we processed these people through. Sadly, we were learning we had to turn some of them away. But lawyers stayed for 15, 16 hours that day to process these records. We had public servants from the administrative office of the courts who came on a Saturday to make sure the records could be fresh. And then we learned how problematic, that was just the beginning. Because the rights, once you even completed the file, the expungement wasn't automatic. Then we had to figure out, and this was with all the resources, frankly, in the world and a big nonprofit civic organization on their behalf, they had to go to court and figure out how to do this. The judges hadn't do it. We have a wonderful clerk of court who's been a great friend of this. It took months just to figure out how would we take these records to court. The administrative office of the criminal records had to be fresher than from the date that we had processed them in February. And this was, again, with everything on your side, it took months and months just to get these cases through judges. Fortunately, the judges were willing to waive fees for the indigent status of the plaintiffs, who were not in court, but we were able to say, if you're coming at 7 a.m. on a Saturday morning to expunge your record, you're probably indigent. And they accepted it. Since then, the Kentucky Court of Appeals has recently said that the law doesn't allow a waiver of fees for indigent status. I hope that our election is going to see that changed quickly. Even the Republican legislators who promoted that bill said we never intended the rights to be we always intended the rights to be waivable, the fees to be waivable for indigent status. So we have a lot of work to go. We've had 2 more clinics since then. We have processed the expungement of by far a majority of the criminal records that have been expunged in Kentucky since we started the program. But I want to talk about the faces that we've put on the story because that's what really happened. The people who came to this clinic are people who made their mistakes, paid their price to society, and are now trying to turn around our community, support their families, be productive members of our community, and we aren't letting them. When you think about it, we have done everything possible to strip dignity away from these people. But I got to tell you, the 800 people that showed up on a snowy Saturday in February, they not only had dignity, they had hope. And that was so inspiring to me and the public officials who were there and the lawyers were there, that they are changing our lives. Because the fact that they are there investing in the future of our community, a future they want to invest in, reminding us through their stories that they want to rent good apartments. They want to be able to buy houses. They want to be able to become a barber. They want to be able to vote. They want to be able to take their children on field trips, which good parents can't do if you have a criminal record in Kentucky. And we aren't letting them, but they haven't given up. So then the clinics we've had more recently, the Sadiqua and the people from the Urban League tell the lawyers, we're processing them now much faster. I could go into the story of how we now have someone with a criminal record creating the files before the clinics. We're now getting them through in 5 or 10 minutes at a time, and no one is being turned away. But we're encouraging the lawyers to sit with them, because that's making the lawyers advocates for this cause. And they're hearing stories. We're hearing stories about the woman who's been clean for she had a criminal record. She was on drugs for 20 years. She's working in addiction treatment, and she wants to get her criminal record cleared. We hear from an 80-year-old woman who comes in and says she doesn't want to die with a criminal record. We have a young man who's been working, building our city, building our Yum Center right here, building our new interstate bridges. He can get contracting jobs from the contractors working on these big public projects, but he can't get a real full-time job with benefits. We see the woman who has had a clean record for over 40 years, but because she has a Class C felony, she will never be able to get her criminal record expunged in Kentucky, and she breaks down in tears. So I want to tell you historians why it matters to tell real stories and put faces on stories. It's deeply important to remind people of the structural reasons for why we are where we are, especially in the South. But if we can tell the stories of real people who are fighting to rebuild and build their communities and families, you will change lives like mine's been changed. Thank you.
Hello, everyone. My name is Amanda Hall, and thank you to my fellow panelists and to our great moderator. So I'm really glad to be here tonight. I work for the ACLU of Kentucky. This is an issue that's very near and dear to my heart because I experienced disenfranchisement here in the state of Kentucky. So I'm originally from Eastern Kentucky, which is a place called Martin County, which is a very, very small place. You may have read about us because we don't have clean drinking water for many years, so it's a very rural, very tiny spot. And I grew up, and, my mom, she always voted. That was her thing. My mom was very feisty, very, she was into making waves and wanted to change the world, but this little good old country girl too. So from a really young age, I knew the importance of voting. In my teenage years, I developed a substance use disorder. After, for years, I loved school. I had all these dreams and visions of going on to college and to being the first person that graduated in my family and making my mom proud. And I had started experimenting with drugs and alcohol like some teenagers do, and then I was in a car accident and got prescribed opioids. So at the age of 18, I started to cycle in and out of jail for offenses such as PI, because in a small town, and we were a dry county, like everybody knew me and they knew I was going to be intoxicated, so it was really easy to arrest. You know what I mean? Like anywhere I went, like grocery store, anywhere, gas station, they knew they can get me. So, and then eventually in my mid-20s, I ended up in prison for it was trafficking pharmaceuticals. It was actually 2 prescription pills, and I got 2 5-year sentences. And at the time, there was more than one women's prison. Now there's only one, but I got sent to the maximum security one. So that's where I went. I got shipped around the state. It was about 3 hours away from where I'm from, and was separated from my family and from my children who didn't have the financial means to come and see me. I never got a visit while I was there. They just couldn't make it there. You know, we weren't a big rich family, and they just couldn't come. So I thought, this is absolutely the lowest point in my life. Like, this is punishment. I'm being punished. One day I'm going to get out, and things are going to be better. It was, you know, this is my punishment. So once I got out and went to substance use disorder treatment and trying to reintegrate into society, I came to realize that was not the end of my punishment whatsoever. So, you know, I couldn't vote, couldn't find housing, I couldn't find employment, all these obstacles. And I went on to be a program director of a women's overnight homeless shelter, and then the largest women's recovery program in the state of Kentucky also. And I remember on the day, on voting days, because all these women in Kentucky now, we're number 2 in the nation to incarcerate women, and we're number 2 for children that have had a parent incarcerated, and we're number 1 for children that live with someone other than their parent. So mass incarceration here in Kentucky is immense. So I remember all these women, and some of them would have their babies there, and they couldn't go vote. You know what I mean? None of us, even here I was, I'm supposed to be this director and giving hope and inspiration, and none of us could vote. We were trying to change ourselves and wanted to make the world a better place for our kids and our families, and we just weren't able to. So I ended up coming to the ACLU of Kentucky because, as much as I love my job working with women and children, I saw how policies were such a hindrance to these folks. You know, because once they got into recovery and got on their feet, I couldn't find them housing. I couldn't find them employment. We couldn't do a lot of things. So I came to the ACLU and started working on policy and going to our state capitol in Frankfort. So my first session going to the state capitol to work on justice reform bills, and one of the expungement bills that Mr. Reilly just alluded to, I thought, okay, if I'm going to do this, then I have to bring my people with me. So we brought over 50 formerly incarcerated folks to the Capitol to meet with legislators, to get folks in front of these lawmakers. And so unfortunately, the big bill that we fought for failed, and expungement failed that session. But luckily, it got passed last session. And it was very weird because the ACLU of Kentucky and the governor of Kentucky doesn't have a very good relationship, okay? So, but we were at that bill signing, and I got the first copy of that expungement bill because of the smart justice advocates and the formerly incarcerated folks that had came there and really poured their soul out. And I want to tell you right now, that's a hard room. That's a hard room to sit in with this person that you know holds your fate, and you tell them the worst thing that you've done. But actually, I've been pretty used to that because there's been a piece of paper that follows me around everywhere I go, you know, and it's always out there for whoever wants to see it. So I had filed for my voting rights under Beshear, former Governor Beshear, and did not get them. So it took over 2 years, and I want to say that I have had a lot of privilege in the criminal justice system. You know, I remember while I was in prison, and something that really I care immensely about is that I went up for parole. I got to go up for parole, and I actually got parole. And my friend in prison, who was a black woman, you know, I got to go to parole and got to go to treatment. She didn't. She had to stay there. So when it comes to disenfranchisement and voting rights in Kentucky, the fact that we disenfranchise so many, number one in the country, African Americans, the rate is absolutely, it's something that Kentucky should be ashamed of. And so I had this application in, and I would call every day. And again, another privilege. The reason I had that application in was my parole officer helped me fill it out. I couldn't fill it out. They asked you for case numbers, all these things. You know, I'd been held with no bail. I didn't know exactly what my sentencing day was, and I'd been shipped around the state and been in this jail, and, you know, all that stuff's very confusing for me when I was going through it. I was sitting in a box with, didn't even have a window. You know, I don't know what day it is or what's going on. And so my parole officer actually helped me fill my application out. And here in Kentucky, you get that application. You have to have it filled out. If any letter, any number is wrong, it gets thrown back. It has to be signed by a probation or parole officer now. And then it gets sent to Department of Corrections, which then sends it to the governor, which then sends it to Secretary of State, which then sends it to Department of Corrections, which then sends it to you. So 2 years later, I called monthly the governor's office. I was so aggravating, which you guys have met me. You can tell, you know, I'm persistent. So, and I would call every month, and the governor's legal aide knew my voice. It's very, you know, it's hard to disguise, but, and so I imagine folks that don't do that or don't know how to do that, you know. And finally, 2 years later, I got my right back to vote. I got it back one day too late to vote in the primary. So then I'm so excited, like overwhelmed, and I send it to the clerk's office, and they tell me on the paper I can, you know, register online, and then they kick me off of that again. Like I get deregistered and then have to fix all of that. But finally, it was a year ago yesterday, I got to vote for the first time since my felony conviction. So, and it would be easy maybe to think that, oh, I have my rights back, it's okay. But I know what that feels like. I know what it feels like to sit in a house with children and to have no say-so in who's going to represent them on the school board or who your governor is or who your representative is. To not have one of those I voted stickers or bracelets. That seems so mild and so unimportant. But when it makes you feel like you're not part of a society, it's a big deal. Because for a long time, I was locked up, and whenever I got into the world again, then I've been locked out of everything. In our legislature, and my time's running out, but it's a very tricky situation with voting rights. But folks may ask some questions. I will be more than willing to answer those. We continue to work on that. We continue to work on expungement. The dream would be automatic. And what's so sad is when I look at restoration for folks, especially when I hear violent and nonviolent, I know folks will get left behind. And it's like that day that I got that signed copy of the expungement bill. My charges aren't expungible, you know. So I was happy for other people, but it hurts to be left around too. That's why I think that everybody should always have the right to vote, or at least restore it. Hopefully, Governor-elect Beshear will think about just restoring it to all folks and not leaving those carve-outs. Okay, thanks.
So one of the worst things I've had to do in recent times is to cut off Amanda Hall and telling her story. So it hurt my heart to hold that 1 minute sign up, and I even gave her an extra minute because every time I hear her speak, I think she just really brings that human face to what this issue is, and particularly in our state. So we have a little time before your reception. I know nobody wants to get in between conference attendees and a reception that's around the corner. But we are saving, the last 12 minutes or so for audience Q&A. And if you all don't have any questions, I can come up with questions. So are there any questions for the panelists? You all just want to go drink. Oh, I see one. Please stand up.
If this problem was eradicated and this
Well, we don't know precisely, and there's two different ways we could do it. One, as you say, after the end of your sentence, or as I would advocate, we should do away with it completely. There are many people speculate, well, this is going to be a very heavily Democratic voting bloc because people of color, African Americans in particular, are disproportionately affected by these policies. That statement is true. It's also true that 45% or so of people with a felony conviction are white people, more likely to be Republican voters if you look at it that way. So the couple of studies looked at this, think there's probably a margin for Democrats, but it's not as overwhelming as some people think. Let me just say, but this is an intriguing intellectual question. I think it's very inappropriate in terms of thinking about the issue. We should be thinking about whether this is a democratic issue or not. What does this mean for democracy? Should people have the right to vote? It makes me think now, 100 years ago, women got the right to vote, and the question was not, are they going to vote Democratic or Republican, but it was the right thing to do. So whether it's partisan politics being for or against it, unfortunately that happens, but I think we should do our best to uphold the value of democracy and see where that takes us.
Any other questions?
How many states are currently in need of changing?
48. Maine and Vermont are doing just fine.
But I also think it's, not an accident we're talking about this issue in front of this group. And so let's be honest, what we've heard is that the issue is a Southern tradition that's entrenched in the former slaveholding states. And so this is a part of the soul cleansing opportunity for our nation that we should take advantage of.
Can I just add that in terms of, I like any framing that says Vermont is doing it right and everyone should be like Vermont, but I really do think that there is room for significant reform in all of those states, especially and also in Vermont, where actually turnout is quite low. We don't really have very good data on this, on how many people who are incarcerated vote in Vermont and Maine, but the numbers are certainly low. So everywhere there is room for, and again, you've been hearing this all night, but there is room for correctional and both in the correctional side and the election side to inform people of their eligibility and to provide them with the documents that demonstrate that their eligibility and to register them. So it's, look, the whole enchilada is a beautiful thing, but there is enormously important progress that can be made in making these processes easier in every state. That is a fun parlor game. We did a little bit of this at dinner, actually, because Tennessee gets some votes because of this crazy time period that Tennessee has. Florida has the numbers, no question about that. Mississippi has the same thing as Alabama in that because they have this infamous crimes restriction where Alabama's moral turpitude, they've been struggling to define it, and some people actually are eligible who are incarcerated but are almost certainly not able to do so for bureaucratic reasons and because corrections isn't helping them. Those would be the nasty final four, I would think, in a lot of, yeah.
Go ahead.
What is the picture that polling gives us on this issue nationally?
Like, what does the public think about this?
Generally speaking, if the question is, should people have the right to vote restored after they completed their sentence, it's in the range of 75% support yes. Should they have the right to vote when they're living in the community under probation or parole supervision, 60%. In prison, it's clearly less than 50%, although there was a vote in Massachusetts almost 20 years ago now. Massachusetts had been a state where people in prison were eligible to vote, and an ambitious politician was able to get a ballot issue on that to try to strip them of that and was successful. And the vote was 2-1 to take away their right to vote. So it meant that, at least a third of the people in Massachusetts did support voting in prison. So that's sort of where we stand today.
The other thing to remember is that the Florida ballot initiative, the Amendment 4, that required more than a majority. It required, I think, 67%, so 60%. So in Florida, it hit 60 on that vote. So it's quite possible that we're talking about majorities here.
Yes.
Yeah. Who's on the right side?
Among politicians.
Among politicians.
Bernie. Bernie Sanders, came out on the campaign trail and said he thinks everybody should vote, including people in prison. And among the other Democratic candidates, they're all variations on when you complete your sentence or when you get out of prison or something like that. Some make distinctions between violent and nonviolent, but Senator Sanders has had the strongest position on this issue. And it's the policy in Vermont, his home state.
In Kentucky, you can see that libertarians actually align a little more with progressives on this issue. I participated in a press conference with Senator Rand Paul, and I couldn't believe the press didn't pick it up when he went on, as he sometimes does, and he said, in fact, I don't even understand why people are in prison for things that aren't crimes now, like crimes against marijuana possession. I thought, did you just hear? He's saying that we should release all these people. And yet Mitch McConnell said, and was quoted recently as saying that on the franchisement issue specifically, he didn't, and I thought this was particularly tinged language in the South, that he didn't think that the votes of law-abiding citizens should be diluted by the votes of criminals. Wow. It's just very resonant of old. I think you would probably find some language about dilution, right, of good people by other people is. And still invoking that kind of language. So it's across the board, but it is totally bipartisan here in Kentucky. The expungement bill that passed was strongly supported by at least the urban chambers of commerce, as well as, obviously the ACLUs and others. So the smart, if you want to talk about the coalition you have that you're part of, because there are lots of people on both sides on that.
Yeah, so we're in a coalition here in Kentucky that is the ACLU of Kentucky, the Kentucky Chamber of Commerce.
Which is a very conservative state chamber.
Very. The Catholic Conference, Council of Churches, we have the Kentucky Coalition Against Domestic Violence. So we even have, and Kentucky Association of Sexual Assault Programs, Kentucky Youth Advocates. So we have the biggest statewide advocacy group for kids in Kentucky. Then we have our victims groups that all come together around criminal justice issues here in Kentucky, because it is such a huge issue here. And all the bills that we work on, like the expungement bill, obviously that was sponsored by and supported by Republicans. So it's very interesting. And there is voting rights bills that have been sponsored or co-sponsored by Republicans here in Kentucky. But one of those bills had carve-outs for the violent crime issues, which I'm always very, very hesitant about, especially here in Kentucky, because when you say violent crime, every year we keep adding to our violent crime statute. It's so immense. Yeah. And also so that would be, as soon as you're done with probation or parole, you would get your rights back. And then there's a bill in the Senate sponsored by a Republican that has a waiting period, which I'm very against too. But at least they're starting to, folks are coming around. And Rand Paul is a huge supporter of voting rights. He's even testified in Frankfurt to our General Assembly on the issue of giving folks their voting rights back. But Senator McConnell is in opposition.
All right, we may have time for one more question. or anything you have to say, panelists, and go for it.
I got one, yeah. It's been a treat to be on this panel because usually when I present my historical research afterwards, everybody asks me questions about the present, which I have to like fake my way through. So it's so nice to have all these people that can talk about the present. But I wanted to then take that opportunity to talk for a second about history, which is that, you know, the present's interesting, but there's still a lot of room here to be done, lots of room for historical research to be done. If those of you that are graduate students or mentoring graduate students, you know, I've written one fairly modest book on part of this story, but there's a lot of work to be done in the 20th century. There's a lot of state level studies to be done. So I really hope that, you know, some of you will write books that have little footnotes which explain that I'm wrong, just as years ago Alec was very generous when I pointed that he was slightly mistaken. So I'd be happy to talk to anyone interested in doing this kind of work about ideas that, you know, of things you might want to dig into.
All right, so that wraps this up. I do want to say, I just said my name. I'm a criminal justice professor at the University of Louisville. So there's that. I'm just not some random person they just, you know, pulled in here. I've really enjoyed this panel. It makes me want to go back and do some more felony disenfranchisement research, which I haven't done in a couple years. But I'm sad that a lot hasn't changed, but I am hopeful for the things that are happening across the country. So thank you all for coming, and thank you to our panelists.